Today, on Capitol Conservatives, Senator John Kennedy takes center stage in the Judiciary Committee, pressing 3 judicial nominees, Judge Baggio, Judge Brisco, and Judge Lund, on critical aspects of constitutional law. From Title VI of the Civil Rights Act to federal preemption, Kennedy puts their legal knowledge to the test. What happens when nominees stumble under pressure? Stay tuned. Before we dive in, hit that subscribe button so you never miss moments like this from Capitol Hill. Judge Baggio begins. Kennedy asks about Title VI of the Civil Rights Act. Baggio hesitates, confusing it with Title VII, then corrects himself. He admits he hasn't litigated Title VI, but promises to study it.
Senator Kennedy.
Thank you, Mr. Chairman. Judge, congratulations. Let me start with Judge Baggio. Am I saying that right?
Yes, sir. Thank you.
Judge, tell me about Title VI of the Civil Rights Act of 1960.
Title VI, I believe, Senator, is the provision of the Civil Rights Act of 1964, which prohibits the discrimination based on religious preferences, I believe. Oh, I'm sorry. May I strike that? I'm sorry, Senator. I was thinking of Title VII. Apologies. As you're well aware, I'm sure from my record, Senator, in my 18 years as a federal litigator, as well as my 4.5 years on the state court bench, I didn't have the opportunity to litigate issues related to Title VI of the Civil Rights Act. So apologies for the misstatement. And were I to be so fortunate to be confirmed, Senator, I would make sure with no uncertainty that I would be fully fluent in that issue were it to be presented to me on the bench.
Okay.
Kennedy moves to Judge Brisco. She assures preparation for Title VI. Judge Lund acknowledges the issue never crossed his bench. None had first-hand experience with Title VI.
Judge, is it Brisco?
It's Brisco.
Brisco,
Senator.
I apologize.
No problem.
Tell me about Title VI of the Civil Rights Act of 1964.
Senator, in my 17 years as a member of the bar and 5 years on the bench, I have not had the occasion to address Title VI in my career. However, if I am so fortunate to be confirmed as an Article III judge, I would certainly research and study to be prepared to address that issue, sir.
Judge Lund?
Thank you, Senator Kennedy. I cannot add anything that my panelists have not otherwise add. I can also assure you, though, in the 15 years that I've had the privilege to serve as a judge, that particular provision has not been put before me, but if it were to, I would faithfully review it and appropriately apply all Supreme Court, United States, and Seventh Circuit Court precedent that's put before me.
Well, Title VI is kind of timely, isn't it? I mean, I'm sure you all read the newspapers, right?
Kennedy shifts gears. He asks Judge Baggio about the standing requirement's origin. This time, Baggio answers, it comes from Article III's cases and controversies provision. Kennedy nods, but keeps pressing forward. Judge Brisco faces questions from Senator Kennedy about the law of the case doctrine. She explains that once a case is decided, related claims can't be relitigated. Kennedy accepts her answer and moves on. Like and subscribe for more coverage of key hearings.
Okay. Judge Baggio, where does the standing requirement come from?
Senator Kennedy, the standing requirement stems from the cases and controversies provision of Article III.
Okay, thank you for that. Judge Brisco, I got it right this time. Tell me about the law of the case doctrine.
The law of the case doctrine is when a case has been adjudicated, then there cannot be any other collateral claims stemming from the issues that were already litigated.
Okay, thank you for that.
Kennedy presses Judge Lund on federal preemption. Lund cautiously says federal law overrides anything conflicting beneath it. Kennedy asks, where does federal preemption come from? Lund points to the Supremacy Clause, but struggles to explain the rule. Kennedy reminds him this is something he'll face often as a federal judge.
Tell me about, Judge Lund, tell me about federal preemption.
Thank you, Senator, for that question. In just using the words in and of themselves, I would assume that the phrase speaks for itself, that federal law would preempt anything else that would come before it. Again, if I were posed with that particular legal phrase, I would do all that I could to faithfully review what specifically it is about and faithfully apply that definition to whatever the situation was that was posed in front of me.
Well, where does federal preemption come from?
Well, federal preemption comes from the Supremacy Clause, that federal laws and the Constitution are supreme and state courts are required to uphold them.
And how do you know if there's federal preemption?
Again, I would look towards Article 6 of the Constitution, which again is the provision in which
You You won't find it there. How do you know when federal preemption happens? You're going to see it a lot as a federal judge.
Thank you, Senator Kennedy. Again, I would be looking towards Supreme Court precedent, Seventh Circuit Court of Appeals precedent to review any of those particular issues that would come before the court and would faithfully apply them.
You don't know the rule for determining federal preemption.
I could not accurately articulate that today. Thank you.
Thank you, Mr. Chairman.
Kennedy exposes a pattern. Nominees often promise to research later instead of showing deep legal knowledge in the moment. His sharp questioning shows how crucial constitutional fluency is for a lifetime federal bench appointment. For more clips like this, click subscribe and join Capitol Conservatives. Kennedy's questioning left all three nominees uncertain. The hearing showed knowledge of the law is essential for the federal judiciary. Stay tuned to Capitol Conservatives. Like, share, and subscribe.